Right. You said you had it. Oh. Oh. You do?
Please be seated. The record will show the presence of the jury, the defendant, and counsel. Good morning, ladies and gentlemen. Did any of you read, see, or hear anything about this case in the media? Did anyone attempt to speak with any of you about this case? Did you speak with anyone about this case? Did any of you do any research about this case? The record reflects that no juror responded affirmatively to any of the questions. All right, ladies and gentlemen, I have excused juror number 5 and juror number 12. They will no longer be part of the jury. We are going to take a recess at this time until 1:30. Please return at 1:30. Are there any questions? Please remember the admonition. Please be seated. The record will show the presence of the jury, the defendant, and counsel. Ms. Wilmot.
Thank you, Judge. Your Honor, defense is in Exhibits 960 and 962.
I've already made my record.
All right. The objections are overruled. Exhibit 960 and 962 are admitted. Ladies and gentlemen, these two exhibits will be put on the Elmo or the overhead screen for you to read. No one will read them to you. You are to read them to yourselves. These exhibits have been admitted and will go back to the jury room with you.
This is 962.
Is anyone still reading? If so, please raise your hand to let me know. All right, you may proceed.
This is 960.
Does anyone need more time? Raise your hand. All right, you may move it up. Do you need more time? Anyone need more time? Raise your hand. Okay. Anyone need more time? All right. If you need more time, raise your hand. All right, Ms. Wilmot. Does anyone need more time? All right, Ms. Wilmot. Does anyone need more time? Ms. Wilmot? Okay. Does anyone need more time? Ms. Wilmot? All right. Mr. Nurmi?
This time you're on the defense rest.
All right, ladies and gentlemen, please go back to the jury room for a few minutes. We will call you back shortly.
All rise for the jury.
Please be seated. The record will show the jury has left the courtroom. Ms. Arias, your attorneys have indicated to the court that you do not wish to allocute. Is that correct?
That's not correct.
All right. Explain.
I would like to allocate.
All right, and you're willing to do that in front of the jury?
Well, yes, to the jury.
Are there any other conditions?
I have the same concerns that I voiced in chambers.
That was back in October of 2014, correct?
Yes.
You understand that the appellate courts have ruled that you may not allocute in a sealed proceeding, or you may not speak or testify in a sealed proceeding. Do you have any reasons other than those you previously expressed?
No, my understanding was that the Court of Appeals said that my testimony cannot be sealed, and that allocution, in my understanding, is not testimony. So that was my only thought.
All right. Well, I think the same analysis applies. I will make the same offer I previously made, and that is we will clear the courtroom. The folks in the courtroom can go downstairs to the overflow room and observe your testimony in the overflow room.
Well, I appreciate that, but it doesn't address my concerns.
So you do not wish to allocute unless you can allocute in a sealed proceeding. Is that correct?
That's correct.
And you understand that the right to allocute encompasses the right to express remorse, plead for mercy, explain the crime, and bring mitigating circumstances to the attention of the jury. You understand that is the purpose of allocution.
Yes.
You do not wish to allocute for these purposes unless you can allocute in a sealed proceeding. Is that correct?
Will you read the purposes one more time? I'm sorry.
Yes. The right to allocute encompasses the right to express remorse, plead for mercy, explain the crime, and bring mitigating circumstances to the attention of the jury.
Okay, thank you.
You cannot allocute in a sealed proceeding. Do you wish to allocute?
Not in an open proceeding, no.
Have you had the opportunity to discuss this matter with your attorneys?
Yes.
Do you have any questions about your decision that you wish to address to the court?
Not at this time.
Have you taken any medication today?
No.
All right, thank you. You may be seated. Counsel approach. Ms. Arias, the reasons that you referenced earlier, those were explained to the court in an in-chambers conversation back on October 30th of 2014. Is that correct?
Yes.
Thank you. Let's bring in the jury.
All rise. Can we approach this briefly?
Yes. Please be seated. The record will show the presence of the jury, the defendant, and counsel. All right, ladies and gentlemen, please return tomorrow morning at 9:30. At that time, I will read the final instructions to you, and the attorneys will give their closing arguments. Any questions? All right, continue to follow the admonition. We'll see you tomorrow morning at 9:30. Thank you. Ms. Arias, I have two additional matters I wish to address with you. You understand that allocution is a statement you make directly to the jury. You're not under oath, and you will not be subject to cross-examination. You understand that?
Can I have just one moment?
Sure.
Yes, I do. Thank you.
Does that in any way change your decision?
No.
All right, thank you. We're at recess until the jury instructions are ready. All right, counsel, have you had a chance to look at the draft of the final instructions?
I have.
Yes, Your Honor, we have.
All right, I know we discussed these earlier on the record at the bench over the noon hour. I was provided with some case law with regard to one of the issues discussed. It is on page 2 of the instruction. The defense objected to the sentence in the third paragraph, which reads that you are not to be swayed by mere sympathy not related to the evidence presented during the penalty phase. This particular instruction has been upheld most recently in State versus Ford, F-O-R-D-E, 233 Arizona 543. It's a 2014 Arizona Supreme Court case. Also State versus Carrion, C-A-R-R-E-O-N, 210 Arizona 54. And State versus Coos, K-U-H-S, 223 Arizona 387. So my prior ruling will stand on that issue. All right. Now, with regard to the other instructions, are there any objections?
No.
None that weren't previously made earlier this morning, Your Honor.
Okay. Just one more thing I wanted to put on the record. All right, the verdict form. I have a verdict form. Counsel, please approach to review it. All right, we are at recess until tomorrow morning at 9:30.
Okay.
Is that another one you're? What's the number?
He wants it. Oh, it is?
Yep.
Oh.
I don't want any copies.
Oh, you don't want
Go them down.
Okay.
It's the, yeah. I just did. Mr. Schatz, can we borrow you for a second? Mike, can we go back on the, Mike, can we go back on the record for just a minute? Yeah. He's here, please. Yeah, back on the record just for one quick thing.
Oh, yeah, okay.
Oh, they have to go back on break.
To see exactly what it's called.
Better.
Thanks.
Let me know when you're ready. Oh, no, we can do it outside. We don't, it doesn't have to be at the bench. We're going to put something on the record. All right, the record will show the presence of the defendant and all counsel. Ms. Wilmot, you are providing some materials to the clerk to be marked or to be retained under seal. Is that correct? These are ex-parte documents that you wish retained?
They are notices.
Ex parte notices filed under seal.
Right.
And there are 3 of them, correct?
Yes.
I want the record to reflect they are being sealed pursuant to court order. I have not seen them or reviewed them. I have no idea what's in the contents, but they're being sealed at the request of the defendant.
The stay or offers of proof only for purposes of appeal, Your Honor.
Okay.
And Judge, I know the court allowed us to supplement. There'll be a supplemental one filed probably first thing tomorrow morning.
And that is also under seal?
Yes, and it's related to what we've already filed.
All right, so I will also order that that submission be sealed, and I will not review it either.
Okay.
All right, thank you.